currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressing that guidance.
After the fact. Yes. After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I mean, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that there's the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thanks.
So the Solicitor General there, John Sauer, Missouri, a Missourian there, arguing on behalf of Trump in the Trump v. Barbara case in front of the Supreme Court. Birthright citizenship is the question, and we are waiting, I guess at the end of June, we'll find out at the latest what the ruling is here. Let's get to somebody who actually knows what they're talking about on this issue. I have lots of questions. Will Chamberlain generally has lots of answers. Senior counsel at the Article 3 Project at Will Chamberlain. Thanks for being back with us, Will. It's great to have you on the show.
Always good to be with you, Amy.
Can I just not even frame the question for you? Can you just react to what you heard today and set us off in a direction that you want people to understand?
I mean, the arguments actually did not surprise me, and I know I've seen a lot of blackpilling from people on the internet. I don't have the same feeling. I think we have a good fighting chance to win this. Basically, I mean, obviously, the progressive judges, Kagan, Jackson, Sotomayor, have no time whatsoever for the administration's arguments on this. They think it's open and shut. But the conservative justices are really troubled by the way that the ACLU has framed this issue. They don't think it's very persuasive. They think it's got problems. And I think the biggest of which is they don't have a really good interpretation of the meaning of the phrase subject to the jurisdiction thereof. They basically say, well, that phrase just means these three exceptions that were discussed at the time of the founding and no more. And the point that the conservative justices make is like, well, then why didn't they say that? Why didn't they say we'll give birthright citizenship to everybody except the children of diplomats, the children of invading armies, and the children of American Indians? And that's it. And instead, they created this general rule, like you need to be born here and subject to the jurisdiction thereof. And that rule implies domicile and allegiance. And so if you extend that rule to cover illegal aliens, it doesn't work. And I think, I don't know which way I'd bet in terms of the outcome here, but I think the administration put forward a really good argument. John Sauer defended it very well. And the ACLU just kind of treated it very flippantly, and I don't think impressed a lot of the justices.
Will Chamberlain speaking with us, senior counsel at the Article 3 Project on X at Will Chamberlain. I remember when this case was filed, when it was going to be heard by the Supreme Court, that there is kind of, in some circles, some laughing like this is a ridiculous case, that the president and the administration wouldn't be successful on it because it's the 14th Amendment. It couldn't be challenged. But it does seem as though from some of the feedback that I'm seeing, including Senator Eric Schmidt of our state here in Missouri, said that this one is going to be close, and we will have to wait to find out what the ruling is. It doesn't seem like it's a slam dunk on either side.
That's right. And I mean, if, people might, they might have listened to the arguments and think, oh, like they asked tough questions of John Sauer, therefore things are going badly. It's like, no, they having read the briefs, they asked the right questions of both sides. I think the Sauer side has to kind of explain exactly what domicile means and, which version of domicile are we talking about? Are we talking about how domicile was understood then? Does it change over time? That's sort of the tricky, thorny part of the argument against birthright citizenship, or basically this argument against it for illegal aliens. But, the arguments they were asking of the ACLU were the right ones too. And they weren't just taking for granted that the ACLU had it right. So I thought it was, we're in good shape. We're in better shape than I think many people would have anticipated. If I'm sitting around here thinking, a supporter of birthright citizenship, I'm not really super happy about how that argument went. I'm just not. I think we've got some problems.
So the question in front of the court is the 14th Amendment, the understanding that if you were born on American soil, that you are born into American citizenship. Obviously we'll have to wait and see what the ruling ultimately is, but I would imagine kind of like the tariff ruling that we were waiting for, and of course that didn't go the way the administration initially wanted it to, that if it rules one way, then the question is, well, what do we do now? Because there are people who are in this country who are citizens because of birthright citizenship. I think the stat I saw on Fox News earlier was 6% of births, 255,000 people a year are a benefactor of the birthright citizenship, if I got that statistic correct. Does this even become retroactive? I mean, people would lose citizenship. Whose job is it to determine that? Should the Supreme Court come and say, well, we're siding with the Trump side?
Well, that's Congress and the executive, right? Like basically all this rule does is set a legal floor about who has to be a citizen, who Congress cannot, Congress has to accept, who the administration has to accept as citizens. Congress has the ability to extend naturalization if they want to people who might be hard cases. They literally are granted the power of naturalization by the Constitution. And then the executive branch can implement those rules. All Supreme Court needs to do is read the law, right, and explain what that provision of the Constitution means. They don't have to be bothered by how exactly it gets implemented, because the only real question is what are Congress and the president not allowed to do? It really doesn't force the president or the Congress to do anything if they rule that the guarantee of birthright citizenship is more limited.
So you think that, I don't know, because I'm not a legal scholar, and that's why we have folks like you, Will Chamberlain, on the show, that kind of like once it's an amendment, it's an amendment. It seems like it should be this untouchable thing. I'm seeing a lot of people who are big experts in the commenting space and the truncated character space talking about why it's absolutely going to go this way or absolutely going to go that way. And then I'm also seeing Senator Eric Schmidt and you yourself saying this is going to be a close one. Are there any particular issues? You've said a couple things here, and I've written them down. Of course, we've heard subject to the jurisdiction thereof, one key phrase, and domicile was another thing that I heard discussed quite a lot. Can you boil down in like super simple form for even me to understand what is going to make this go one way or the other?
It's going to come down to did the framers of the 14th Amendment write a general rule that people could come up with future applications of, or did they come up with essentially try to create a rule where there were just this limited closed set of exceptions? Because if it's a general rule, then it's hard to see how it wouldn't apply to illegal aliens. So that's the key thing the court has to decide.
And then I also heard that I think it was Lawrence Jones maybe who was reacting to this. I can't remember who it was on Fox News, but was talking about questioning if they talked enough in the arguments. And I guess, it wasn't a lot of time to make an argument for something like this. You got to kind of get to the point and answer all these questions from all these justices. But saying that the consequence of it staying in place right now, if you had 8 billion people come onto an airplane and come here and have babies, I guess they're all citizens here. Like, is that a reasonable, feasible way to run a country? Does the consequence of something like this policy, to the extreme, is that considered by justices when they're trying to decide on a case like this? In
small part, but in general, I guess it would be if they viewed it as an extremely close and ambiguous case, they might look more at consequences. But in general, what they're trying to do is look at what's so-called the original public meaning. They're trying to, as a sort of consistent basis, not the progressives in the court necessarily, but the conservatives are. And so they're more interested in trying to understand what did these words mean at the time they were at the time of enactment. And that's what they're trying to focus on. And you notice that's why maybe the questions seem a little abstruse to like a normal person. Like, who cares what the random senator in 1860 said during the hearings? Like that why does that matter more than the consequence of just granting birthright citizenship outright? But it's because of a legal theory called originalism, which conservatives have really supported for a very long time, trying to explain that, trying to come up with a consistent basis, a principled way to come up with Supreme Court rulings about what the Constitution says, what the law says.
Senior counsel at the Article 3 Project, Will Chamberlain, speaking with us right now. Go to article3project.org to learn more about the organization. Just kind of in summation of what you're talking about, you've got to go back and look at the original intent. It's hard for me to sit here and think that the framers, the people who wanted to create a country by the people for the people, it's hard for me to think that they would be like, Yeah, if anybody can get across the border and have a baby here, they should be able to be a part of this too. That's just hard for me to think that that would have been the intention. I know you'd have to prove it, but that's just hard for me to believe.
Yeah, I think that's correct analysis. It's really it's the thing about this whole problem is that it's a really something that wouldn't have occurred to people in the 1860s because travel was so challenging. And so, temporary sojourners is is the phrase used. We're such a small category of people that you think like the court would have just assumed like, this is just really is not going to come up that much, or the framers rather would have thought this isn't just going to come up that much. This is about, we have all these slaves here. They need to meet granted citizenship, and that needs to be permanent. That needs to be something that the South can't change back if they ever gain enough political power. That needs to be durable. So that's the underlying purpose of the 14th Amendment, and the immigration applications are just things that come in at a later date.
Will, my co-host Ryan Wiggins is begging to ask some questions here, so I'm going to let you, Ryan, go ahead.
Will, I've been waiting to ask you a couple questions all day. One of them is that I keep hearing going into these oral arguments that one of the possibilities is that the Supreme Court could almost punt on this issue entirely, that we really wouldn't get a ruling on birthright citizenship, and they might say something like, well, it's an executive order, the president can't issue an executive order on this, and that would be the end of it. Is that a possibility?
I don't think so. I think that there's, I don't think there's any really principled basis on which to say that there's no legal authority to issue an executive order that attempts to interpret federal statutes. So, and therefore that even if the interpretation is the correct one, that would fly. So no, I don't think that's a viable approach at all.
So the other question I had for you, you've addressed this a little bit, but I just want to make sure that I'm getting it right. When you talk about originalism, when you talk about, or when people bring up the argument that, hey, this is change, this is being abused now, this law, I think everybody would agree across both sides of this political spectrum, I would hope, that the way that this is being used now with somebody flying into American Samoa, having a baby and leaving in 2 days, provide citizenship, that was never the intent of the law. Is that actually something that these justices consider, though, or are they just going back to what the intent was when it was written?
So they're not looking at intent. That's the key thing to understand. They're looking at meaning. That's the big distinction I think people miss. It's not that the question is not what was in the minds of the drafter. The question is what would the words on the page have meant at the time? And it's an important distinction. It does mean that how the drafters talked about the bill is relevant, but it's relevant in a different way. Rather than giving insight into some telepathy into their minds, rather it's a way of understanding what these words meant in common parlance.
Will, do you ever make predictions? You probably don't.
I do, I bet. I mean, I think
honestly,
this is not, but think in terms of probability. And I think that, you force me to pick here, I think we'll probably lose, but I think it's like 55-45.
5-4 loss?
Yeah, something.
Yeah,
it's probably a 5-4 loss. That's my guess.
All right. Well, we will wait and see. And Will, you're always a pleasure to have on the show. You break it down for us. Very, very helpful to have you on with us. So thanks for the time today.
Absolutely. Happy to do it.
Yep. Have a good Easter week.